Welcome to Do It for the Case Law for Thursday, July 16th, 2026. Visit doitforthecaselaw.com to listen to more in-depth per-case reporting. Today's docket features 48 federal appellate opinions across 10 circuits. Our coverage includes criminal justice matters with James Taylor, civil rights and employment issues with Aisha Johnson, Supreme Court and constitutional law updates from Michael Reeves, immigration and administrative reviews with Patel, and business and tort cases handled by Maria Santos. Subscribe to the show for daily analysis of federal appellate decisions. Do It for the Case Law is a news reporting service. We summarize and discuss federal appellate opinions. Nothing in this broadcast constitutes legal advice. Let's turn to James covering criminal justice.
Thanks, David. 17 criminal justice cases across the circuits today. The disposition mix includes 8 affirmances, 1 dismissal, 1 denial of a motion, 3 reversals or vacators with remands, and 4 other dispositions including a dismissal and denials. We begin with movements on appeal. In the First Circuit, the court vacated and remanded the case against Kevin Jadiel Figueroa Roman after finding the district judge's sentencing rationale ambiguous regarding his association with convicted felons, which frustrated meaningful appellate review. Over in the Eighth Circuit, the court vacated part of Brandon Jones's sentence to remove a sex offender registration condition that was erroneous given he had no such conviction, while affirming the remainder of his term. In the Ninth Circuit, the panel reversed summary judgment in Alliance for the Wild Rockies versus Higgins regarding the Healthy Forest Restoration Act, holding that the group did not need to exhaust administrative remedies before challenging the Forest Service's application of a categorical exclusion. Moving to routine outcomes by circuit. The 11th Circuit affirmed Augusto Reyes Gonzalez's sentence for drug trafficking and re-entry, upholding a dangerous weapon enhancement because he facilitated a firearm purchase during relevant conduct. In the 5th Circuit, 3 cases were resolved affirmatively. Rudy Naranjo's denial of compassionate release was upheld after a fresh review of statutory factors. Arturo Gaetan Portales's illegal re-entry conviction stood as the recidivism enhancement is foreclosed by Supreme Court precedent, and Jesus Rodriguez Garza's sentence for transporting aliens was affirmed based on a co-conspirator's weapon possession. The 6th Circuit also affirmed 2 convictions: Samuel Aurelio Hernandez's felon in possession charge where probation officers had reasonable suspicion to search his residence, and Kenneth Collins's denial of a 3rd compassionate release motion due to insufficient evidence of extraordinary reasons. In the 7th Circuit, Jermaine Stapleton's supervised release revocation was affirmed as the district court properly considered forward-looking factors rather than retributive ones. The 8th Circuit issued 4 additional affirmances. Tazell Tiandre Williams's appeal was dismissed under Anders for having a valid appeal waiver. Dave Shumpert III's felon in possession conviction and sentence were upheld consistent with historical firearm regulation traditions. Davian R. Williams's drug and firearm conviction survived sufficiency challenges, and Saladian Salayan's supervised release revocation was affirmed under plain error review. Finally, in the 9th Circuit, Kenneth Daniel Tiedemann's supervised release revocation was affirmed where constitutional claims regarding passwords were rejected, and Jesus Salayan's appeal for methamphetamine distribution was dismissed because his plea agreement contained an enforceable waiver. Back to you, David.
Thanks, James. Aisha has the civil rights coverage.
Thanks, David. We have 4 cases in this block, all affirmed. In the 10th Circuit, the court affirmed summary judgment for the Creek County Sheriff and Turnkey Health Clinics in White against Bowling, dismissing a Section 1983 claim that officials were deliberately indifferent to an inmate's serious medical needs before his death. The court required expert testimony to prove causation given the complex medical issues and intervening failures at the hospital where the inmate was transferred. Moving to the 11th Circuit, the court affirmed the dismissal of Lily Middlebrooks against Bond, James Bond, Inc., ruling that private bail recovery agents were not state actors under Section 1983 because they did not satisfy the public function, state compulsion, or joint action tests. In the 7th Circuit, the court affirmed summary judgment for the Department of Veterans Affairs in Abayomi against Collins, finding insufficient evidence of race discrimination or retaliation under Title VII of the Civil Rights Act of 1964, after the agency cited careless work performance and medication policy violations as the reason for termination. Also in the 7th Circuit, the court affirmed the City of Chicago's decision to terminate firefighter Sam Inendino against Nance Holt, ruling that while his racially charged Facebook posts touched on matters of public concern, the city's interest in workplace efficiency outweighed his First Amendment rights under the Pickering balancing test. Back to you, David.
Thanks, Aisha. Let's turn to Michael covering Supreme Court and constitutional law.
Thanks, David. We have 5 cases in this block, 3 affirmances, 1 denial of a certificate of appealability, and 1 dismissal. Starting with the 10th Circuit, the court affirmed Willie Davis's habeas denial, holding that the statutory exemption for military institutions does not apply to federal civilian prisons like ADX, so the Bureau of Prisons retained authority to revoke his good conduct time. The same circuit denied Donald Cray a certificate of appealability, finding his claims of ineffective assistance and false testimony procedurally barred by state law as an independent and adequate ground. Moving to the Fourth Circuit, the court affirmed the dismissal of Jamie Brown's challenge to his Air Force convictions, ruling that federal review is limited to jurisdictional errors or cases where military courts failed to address claims fully and fairly. Over in the Fifth Circuit, Robert Hedrick's appeal was dismissed for lack of jurisdiction because he filed a late notice of appeal and his other motions were deemed unauthorized, leading to a $300 sanction for frivolous filings. Finally, the Ninth Circuit dismissed the state of Nevada's appeal as moot since Brown voluntarily entered a new plea agreement resulting in a misdemeanor conviction, making it impossible for the state to reinstate the original felony judgment. Back to you, David.
Thanks, Michael. Let's turn to Maria for business, labor, and civil law.
Thanks, David. We have 14 cases on the docket today. The disposition mix includes 8 affirmances, 1 dismissal, 2 denials of review, 2 vacatures and remands, 1 vacatur with partial affirmation, and 1 other ruling involving a denial of rehearing. We begin in the Fifth Circuit where 2 cases were decided. First, the court affirmed the lower court's judgment holding that the heirs parties willfully violated the automatic stay under federal law by continuing to pursue a deposition and arbitration after With Purpose Inc. filed for Chapter 7 bankruptcy. The court found the respondent had standing as an injured creditor and that the breach of fiduciary duty claim constituted property of the estate. Second, the Fifth Circuit remanded a construction dispute following a Supreme Court decision that vacated the prior affirmation, instructing the district court to reconsider whether an omission from bankruptcy schedules was inadvertent rather than based on knowledge or motive. Moving to the Seventh Circuit, 1 case was affirmed. The court held that a property tax purchaser in Illinois holds a tax claim under federal law, entitling the creditor to an interest rate set by state statute rather than the market-based formula established in Till v. SCS Credit Corp. In the Eighth Circuit, the court vacated a class certification order and remanded with instructions to dismiss for lack of standing. The plaintiff alleged a universal design defect in a Sig Sauer pistol but admitted never experiencing any malfunction or injury, failing to meet the manifest defect rule required for Article 3 standing. Over in the Ninth Circuit, we have 4 substantive rulings. The court affirmed summary judgment in a franchise dispute, ruling that appellants did not waive their right to appeal despite stipulating to the form of judgment. Next, the Ninth Circuit affirmed summary judgment for Talkdesk Inc. against its former general counsel, finding he breached fiduciary duties by assisting a competitor and violated his proprietary information agreement by retaining confidential communications. The court also vacated a remand order in a Luxottica case, holding that the district court must first allow the removing defendant to waive the adequate remedy at law objection before denying equitable jurisdiction. Additionally, the Ninth Circuit denied petitions for rehearing en banc in a Second Amendment challenge to California's switchblade regulations, upholding the summary judgment because plaintiffs failed to show no set of circumstances exists where the ban is valid. In a split outcome, the court granted review on a withholding of removal claim while denying it for asylum and Convention Against Torture claims due to waiver and substantial evidence support. Finally, in the Federal Circuit, we have 3 rulings. The court affirmed the denial of a petition to enforce a settlement agreement with the Department of Veterans Affairs, holding the plain language required payment directly to the appellant rather than his representative. It dismissed an appeal for lack of jurisdiction because the dispute involved applying law to facts rather than a pure question of law. Lastly, the court affirmed in part and vacated in part a copyright damages award, rejecting the use of the Book of Wisdom doctrine to consider unforeseeable future project cancellations while allowing a hypothetical negotiation framework for calculating damages. We have 2 additional Federal Circuit affirmances that are routine in nature. Back to you, David.
Thanks, Maria. Raj joins us now with the latest on immigration appeals and government agency reviews.
Thanks, David. We have 8 cases to cover today across 5 circuits. The disposition roll-up is 2 reversals and 1 vacatur remand, 1 dismissal, and 4 denials or affirmances. Leading with the movements, the Federal Circuit reversed a commerce determination in a steel subsidy case involving Dongbu Steel, finding that the agency correctly re-evaluated debt-to-equity conversions to find countervailable benefits under administrative law standards. The court also vacated and remanded a service member's fitness petition from the Board for Correction of Naval Records, holding that the board failed to apply the correct statutory standards and afford liberal consideration to the appellant. Moving to the 11th Circuit, the court affirmed a tax court judgment upholding IRS penalties against Savannah Shoals for overstating the value of a conservation easement, rejecting a claimed $23 million deduction in favor of a fair market value of $480,000. In the 4th Circuit, 2 immigration petitions were denied. First, the court upheld the denial of asylum and Convention Against Torture relief to Flores Tercios, finding substantial evidence that the MS-13 gang targeted him for economic reasons rather than a protected ground. Second, Samra Adele's petition was denied regarding her inadmissibility due to alleged willful misrepresentations, with the court confirming it lacks jurisdiction to review factual challenges in such removal orders. Over in the 6th Circuit, Berlin Espinoza-Reyes's asylum claims were denied because her proposed gender-based social groups were impermissibly defined by the harm suffered, following recent guidance on particularity and social distinction. Finally, the Eighth Circuit affirmed a Social Security denial for Sierra Carter, ruling that the administrative law judge properly evaluated her chronic pain and residual functional capacity with substantial evidence. The Federal Circuit also dismissed an appeal in Murillo, where the appellant withdrew to participate in the IRS Blue Bag program. Back to you, David.
That brings us to the end of our broadcast for Thursday, July the 16th, 2026. We want to thank James Taylor for covering 17 cases on criminal justice, Aisha Johnson for 4 civil rights updates, Michael Reeves with 5 constitutional law stories, Maria Santos for 14 business and labor matters, and Raj Patel for 8 immigration and government reviews. Today's docket saw 27 affirmances, 10 dismissals, and 11 other dispositions, including reversals, vacators, and remands that shaped the day's legal landscape. Several appeals were dismissed on procedural grounds or for lack of jurisdiction. Visit doitforthecaselaw.com to listen to more in-depth per-case reporting. Do It for the Case Law is a news reporting service. We summarize and discuss published federal appellate opinions. Nothing in this broadcast constitutes legal advice. We are not lawyers. If you need legal counsel, consult a licensed attorney in your jurisdiction. Please subscribe to the podcast and follow us on social media for daily updates.